ladies and gentlemen. Thank you for being here today. We are gathered here for the happy occasion of the launch of this book titled Corporate Insolvency Resolution Process and Liquidation under the Insolvency and Bankruptcy Code 2016, authored by Honorable Mr. Justice Nageswara, former Judge of the Supreme Court, and Avinash Krishnan Ravi, Advocate. We will be starting now. Let me begin by inviting the dignitaries on stage for the event. Firstly, I request Honorable Mr. Justice Ramakrishna Prasad to come on stage. Mr. Justice Prasad is presently a sitting judge of the Honorable Andhra Pradesh High Court at Amravati. I think we all know him as a veteran advocate and record of the Supreme Court before his present avatar, and also a chamber colleague of Justice Rao. So thank you for being with us today. Next, I request Honorable Mr. Justice Rohinton Nariman, former Judge, Supreme Court of India, to kindly come on stage. As we know, Mr. Justice Nariman has authored, amongst several other things, extremely important judgments under the IBC. His journey first as an advocate and later as a judge of the Honorable Supreme Court will no doubt inspire all of us for generations to come. So thank you for being with us today. Next, I request Honorable Mr. Justice Ashok Bhushan, former judge of the Supreme Court and present chairperson of the Honorable National Company Law Appellate Tribunal, to come on stage. As we know, the NCLAT is one of the most important adjudicatory forums that decides cases under the IBC. We are fortunate that Mr. Justice Bhushan has been entrusted with the task of heading the NCLAT and thereby play such an important role in the growth of the IBC. So thank you for being with us today. Lastly, I request Honorable Mr. Justice Nageswara Rao, former Judge, Supreme Court, and joint author of the book that is to be launched today, to join us on stage. Mr. Justice Rao has mentored and been a source of inspiration for several of us younger advocates in the audience. So thank you for being here, and it's your launch. Before we proceed to the welcome address, we would be presenting mementos to the dignitaries on stage. I first request Mr. Jayant Mutturaj, Senior Advocate, to present a memento to Honorable Mr. Justice Ramakrishna Prasad. That's it. Next, I request Master Sachit, grandson of Justice Rao, to present a memento to Honorable Mr. Justice Nariman. I request Miss Amrita, granddaughter of Justice Rao, to present a memento to Honorable Mr. Justice Bhushan. Lastly, I request Santosh Krishnan, Advocate, to present a memento to Justice Rao. Now I request Justice Prasad to deliver the welcome address.
Very good morning to you all, dignitaries on the dais, dignitaries off the dais, my former colleagues at the bar, senior counsel, a very warm welcome to you all. Today, we all have assembled here for the launching of a treatise called the Corporate Insolvency Resolution Process and Liquidation under the Insolvency and Bankruptcy Code 2016. Now, going a little back before, because this code has come into existence in the year 2016, 28 May 2016. Prior to that, we had the Sikh Industrial Companies Act of 1985, under which we had this industrial reconstruction by way of the Board for Industrial Reconstruction and Financial Construction Act. And then the process of insolvency that is being dealt with, the bankrupt companies, and then the liquidation then under the Companies Act was a time-taking process, and it has never achieved its results. In the year 2016, this act has come into force. Now, if you think of the Hamlet of Shakespeare, the Merchant of Venice, the Sherlock Holmes, the story is about the hapless borrower in the hands of an unscrupulous professional moneylender. Today, in the corporate world, if Shakespeare was alive, probably he would have written another Hamlet as regards the woes being faced by the financial institutions and banks in recovering their monies from the unscrupulous borrowers as well. So this probably would have been the story, and this is the story of the Insolvency and Bankruptcy Code, which it intends to achieve. So it's only about 6 to 7 years now, but even then, by the activism of the National Company Law Tribunals and the National Company Law Appellate Tribunal, the Supreme Court, the honorable judges who have been shaping and then reinforcing the enactment in order to achieve its proper implementation, their judgments have enriched the Indian jurisprudence a lot. And of course, we are still evolving. The members here on the dais would need no introduction at all. As lawyers, as senior lawyers, we all have briefed them, and then, of course, our Indian jurisprudence also has been enriched with their presence on the bench of the Supreme Court as well. Honorable Justice Ashok Bhushan, in fact, is presently the chairperson of NCLAT. It is indeed my privilege to be welcoming you all on this beautiful morning. So, I welcome each and every one of you from the bottom of my heart to have been here, sparing some time. I particularly, even Justice Rao's family members who are all here. And also, in fact, I must also make a mention of Justice Rao's school friends who also have been here. They have always been with him in all such milestones in his life. I welcome you all very heartily and warmly. Thank you very much.
Thank you, sir, for those words of welcome. I now request Avinash Krishnan Ravi, advocate, who is also the joint author of the book, to kindly join us on stage for the book launch. I now request Honorable Mr. Justice Bhushan to kindly deliver his introductory remarks about the book. Thank you.
Respected Brother Justice Rohinton Nariman, Justice Nageswara, Justice Prasad, Judges of Honorable Supreme Court present in this hall, my former colleagues in the Supreme Court, Judges of Delhi High Court, Learned Attorney General, senior members of the bar, other dignitaries, family members of Justice Nageswara Rao, member of the NCLT Srisha Merla, and other members of NCLT present. Ladies and gentlemen, a very good morning to all of you. Esteemed colleagues, it is a great honor and privilege for me to stand before you today to introduce the seminal work of Justice L. Nageswara Rao and Sri Avinash Krishna Ravi's commentary on corporate insolvency, resolution process and liquidation under Insolvency Bankruptcy Code 2016. I commend them for their meticulous research, deep understanding of the law, insightful analysis, and their effort in presenting a comprehensive commentary on the Insolvency and Bankruptcy Code. The Insolvency and Bankruptcy Code 2016 has brought about a sea of changes in the way corporate insolvencies and liquidation were handled in India. It has provided a much needed structure and a streamlined approach, facilitating the timely and efficient resolution of insolvency and liquidation cases. This comprehensive commentary is an invaluable resource that dwells deep into the intricacies of the Insolvency and Bankruptcy Code and provides a thorough analysis of the various provisions. This commentary provides a meticulous analysis of the code encompassing its various provisions, regulations, and judicial pronouncements, making it an indispensable guide for professionals navigating the complex terrain of corporate insolvency. Structured in 38 chapters, this commentary covers a wide array of topics related to the IBC, including definitions, threshold for corporate insolvency, admission into the corporate insolvency resolution process, timelines, limitation, moratorium, liquidation of corporate debtors, schemes under Section 230 and 232 of the Companies Act 2013, in liquidation, voluntary liquidation, and dissolution of corporate persons. The depth and detail of this work truly set it apart, making it an essential read for anyone practicing in the field of insolvency law. The author's mastery of the subject matter is evident throughout the book. Their ability to articulate complex legal concepts with clarity and precision is truly commendable. For instance, in Chapter 7, titled Limitation and Insolvency and Bankruptcy Code, the authors have lucidly explained issues ranging from applicability of the Limitation Act to the insolvency proceeding and thereafter to the limitation period. Also, divergent views about the applicability of provisions pertaining to the extension or exclusion of a limitation period, that is pertaining to acknowledgement, bona fide prosecution of the other proceedings, etc. have been discussed by citing case laws. Furthermore, the book provides practical guidance on issues that insolvency professionals and legal practitioners face daily. An important aspect of the IBC, as discussed in Chapter 12 of the commentary titled Constitution, Meeting and Voting of the Committee of Creditors, addresses the issues of disqualification based on the related party status. However, if a related party financial creditor divests itself of the shareholding or ceases to be a related party with the sole intention of participating in the COC and sabotaging the corporate insolvency resolution process by diluting the votes of others or otherwise, it would be in line with object and purpose of the first proviso to Section 21(2) to consider the former related party creditor as one debarred under the first proviso. In conclusion, Chapter 12 dwells deep into the complexities of the Committee of Creditors and the disqualification of related parties. The chapter provides valuable insight and guidance to legal practitioners, insolvency professionals, and other stakeholders navigating the intricacies of the IBC. Furthermore, in Chapter 12, the authors examine disqualification based on related party and state that it is person-centric and not transaction-centric. They argue that often a debt at the inception may be a related party transaction but may not continue to be so. A subsidiary company may have lent money to its holding company. At the time of lending, the transaction is clearly a related party transaction. In such circumstances, a question may arise as to whether the erstwhile subsidiary would be a related party in the COC of the corporate debtor, owing to the fact that transaction at its inception was at the inception a related party transaction. The answer to this has been given in the negative, as the disqualification for a related party is person specific and not transaction specific. The book provides practical guidance on issues that insolvency professional and legal practitioners face daily. The authors examine the imposition of the moratorium during CIRP. The state the moratorium under Section 14 of the Code is intended to maintain the status quo and preserve the debtors to assets during the CIRP. It is a critical tool that enables the resolution professional to carry out the resolution process effectively without the threat of creditors or other parties taking actions that could potentially jeopardize the debtor's business or assets, unquote. The commentary's practical application and real-world examples make it a valuable resource for legal practitioner. For instance, in Chapter 22, list of stakeholders, constitution of the Stakeholders Consultation Committee, its meeting and powers. The author analyzed the definition of the term stakeholders. The term stakeholder is of a wide purport and covers any person who has a financial interest with a corporate debtor. All stakeholders are required to file their claims before the liquidator, who shall admit or recede the same in accordance with law. After such decision on the claim, filed, the liquidator, in terms of Regulation 31, in terms of regulation, is required to prepare a list of a stakeholder. This analysis demonstrates how the book's insights can be applied to real-life scenario faced by insolvency professionals and legal practitioners. In a field where the legal landscape is constantly evolving, the commentary fills a crucial gap in the current literature and insolvency and bankruptcy law. The authors have meticulously researched and analyzed various judgments and case laws, offering critical insight into the interpretation and application of the IBC. As a result, the book will undoubtedly serve as a valuable resource for years to come. One of the key strengths of this commentary is its ability to provide a holistic understanding of the IBC. In doing so, it sheds light on the interplay between various provisions and their practical implication. For example, in Chapter 27, Sale in Liquidation, the authors discuss voluntary liquidation and its significance within the broader framework of the IBC. They highlight how this process enables corporate debtors to take proactive steps in initiating liquidation proceeding when they believe that business is no longer viable. This not only empowers the debtor to manage their financial distress, but also ensures an orderly winding up of the company's affairs, thereby safeguarding the interests of stakeholders. Moreover, the authors have also taken great care to ensure that their commentary remains relevant in the context of the evolving legal ecosystem. They have thoroughly examined recent amendments in the IBC and pertinent case laws, offering valuable insight into their implication for insolvency professional and legal practitioner. For instance, in Chapter 29, titled Completion of Liquidation and Dissolution, the authors discuss the completion of liquidation and dissolution, highlighting the importance of the time-bound nature of the liquidation process. They note that liquidation must complete the process within a period of 1 year from the liquidation commencement date, as stated in Regulation 44(1) of the Liquidation Process Regulation. In cases where an application for the avoidance of transaction is pending before the NCLT, the liquidation process must still be completed within the stipulated 1 year period. This demonstrates the author's in-depth understanding of the regulations and their practical implication for insolvency professionals. In Chapter 31, fast-track corporate insolvency resolution process, the authors discuss the recent amendment in the time period for completion of the fast-track corporate insolvency resolution process. They provide an insightful analysis of its impact on the resolution process and highlight the need for striking a balance between protecting the interests of creditors and ensuring the viability of the resolution process. As per section 31(2) of the commentary, the time period for the completion of fast-track CIRP is set forth in section 56(1) of the IBC. According to this provision, subject to section 56(3), the fast-track CIRP must be completed within 90 days from the insolvency commencement date. However, section 56(2) allow for an extension of 90 days period if approved by the Committee of Creditors through a vote of at least 75% of its voting share. Moreover, section 56(3) of the IBC empowers the NCLT to approve an extension of the fast-track CIRP period by up to 45 days upon the application of the resolution professional. This extension can only be granted once. The procedure for seeking extension is outlined in Regulation 39(1) of the Fast-Track Insolvency Resolution Process Regulation 2017. According to this regulation, if the COC believes that fast-track process cannot be completed within the stipulated 90 days, it may instruct the resolution professional to apply to the NCLT for an extension under section 56 of the IBC. Regulation 39(2) further states that upon receiving instructions from the COC, the resolution professional must apply to the adjudicating authority for such an extension. Therefore, the maximum duration for the completion of the fast-track corporate resolution is for 145 days. This book is more than just a mere commentary on the insolvency and bankruptcy code. It is a testament to the author's passion for the subject, their diligence and their unwavering commitment to enhancing the understanding of insolvency laws in India. It is a treasure trove of knowledge, and I firmly believe that it will play a pivotal role in shaping the future of insolvency laws in our country. Introduced in 2021 through an amendment to the IBC, the pre-pack CIRP is a unique insolvency resolution process specifically tailored for micro, small and medium enterprises. This process is incorporated under Chapter 3A of the IBC, reflecting the growing recognition of the distinct challenge faced by MSMEs during insolvency proceeding. The rationale behind the introduction of pre-packs can be traced back to the report of the Insolvency Law Committee on the pre-pack insolvency resolution process published in July 21. The report acknowledges the vital role that MSME play in the economy and the unique difficulties they face in surviving financial crisis. The pre-pack was conceived as a targeted response to address these challenges, offering a mechanism tailored to the need of MSME. In the words of authors in Chapter 37, titled Pre-Packed Insolvency Resolution Process under IBC, I quote, "The reason d'etre for providing such a process exclusively for MSME facing insolvency can be traced back to the report of the Insolvency Law Committee on Pre-Packed Insolvency Process 2021, which observed as follows. Access to an effective insolvency law is crucial for MSMEs to survive financial crisis. By focusing on the pre-CIRP, the authors demonstrate their commitment to offering a well-rounded understanding of the IBC, addressing both the general provisions and the specific measures designed to cater to the unique need of different sectors. The in-depth analysis of the pre-pack in their commentary highlights the significance of this process for MSMEs and offers valuable guidance to legal practitioners and insolvency professionals working with these enterprises. Additionally, the authors offer valuable insight into the NCLT's discretion in extending the time limit for completing the liquidation process, as there is no outer limit prescribed for the purposes of completion of liquidation, unlike the 330 days limit for the corporate insolvency resolution process. They highlight that NCLT would determine on a case-to-case basis the necessity for such extension and the conduct of its liquidation during the liquidation process as to whether the liquidator has performed their functions in a different and sincere manner, keeping in mind the model timeline for the liquidation process set out in Regulation 47 of the Liquidation Process Regulation. The authors also draw attention to the challenge faced in liquidation in completing the liquidation process due to the pendency of applications for avoidance transaction, fraudulent trading. Regulation 44A of the liquidation process provides a mechanism for the assignment of avoidance application in liquidation which the liquidator can utilize to expedite the liquidation process. The depth and details of this work, as demonstrated by the insightful excerpt mentioned above, truly set it apart from in the field of insolvency law. The author's mastery of the subject matter is evident throughout the book. Their ability to articulate complex legal concepts with clarity and precision is truly commendable. In conclusion, corporate insolvency resolution process and liquidation under Insolvency Bankruptcy Code 16 is a masterpiece that offers a comprehensive, insightful and practical analysis of the IBC. It is an indispensable resource for insolvency professional and legal practitioner alike, provides them with the knowledge and understanding they need to navigate the complex world of insolvency law. I wholeheartedly recommend this book to anyone seeking to deeper with their expertise in the vital area of the law. With that, I would like to express my heartiest congratulations to Justice Rao and Mr. Ravi for their outstanding accomplishment in creating this exceptional commentary. I am confident that their work will inspire and empower countless professionals in the field of insolvency and bankruptcy law. I am honored to have been invited to introduce this remarkable book, and I wish you all a fruitful and engaging discussion as we delve into the many insight and application. Thank you. Jai Hind.
Thank you, sir, for those kind words of praise and introduction. I now request Honorable Mr. Justice Nariman to deliver his address.
My dear Nagesh, Mr. Ravi, dignitaries on the dais, my sisters and brothers, both from the bench and from the bar, the learned Attorney General, Mr. Venkatramani, ladies and gentlemen. It is an extremely difficult thing for a judge to construe a statute on a tabula rasa, so to speak. And it was my great fortune that the Insolvency Code was in fact a code which had not yet been touched before it came to my hands. You have just been told about how n number of regimes before the code were tried and failed. They were all really in the backdrop, as the first speaker said, of the horrible creditor who was really the individual moneylender who charged compound interest, and the poor individual debtor who was squeezed out of hearth and home, which is so beautifully exemplified in The Merchant of Venice. Incidentally, in The Merchant of Venice, Shylock was the creditor, and Shylock got a very raw deal because he was sick of being called Jewish. And the guarantor, Antonio, who had guaranteed Bassanio's loan, kept on referring to him and his community in very derogatory terms. So he decided that he will now enforce the guarantee in a most peculiar way. He will not ask for compound interest as he usually did, but he will ask for a pound of flesh instead. And the pound of flesh was recorded in the bond. And in according to the laws of Venice, this was something that could validly have been done. Ultimately, of course, when Antonio defaults and Shylock wishes to enforce his bond, Bassanio's wife Portia dresses up as a young attorney called Balthazar and then comes before the Duke. And the Duke says, "Yes, learned attorney, please tell us what the laws of Venice have to say on this." And Balthazar then tells the court that, yes, the pound of flesh has to be taken from Bassanio closest to his heart, and the laws of Venice will allow it. Now, just as Shylock is getting ready to take out the pound of flesh and has already said, oh, Daniel, come to judgment. What a great judge this is. Finally, she says, oh, but tarry a minute. You cannot, however, drop a single blood, a single drop of you cannot shed a single drop of Christian blood. And then Shylock says, but then how do I cut through? So I said, that's not part of the bond. I don't know how you cut through. That's your business. And ultimately, of course, finally, he is made to go home not only without interest, without principal, because neither principal or interest are mentioned in the bond, but made to go home with all his property forfeit. Because another law of Venice said that aliens, and Jews those days were considered aliens, could not possibly attempt the murder of a Venetian. And this was attempted murder. So therefore, half the property got forfeited to the Duke and half got forfeited to Antonio. The Duke immediately said, I will remit my half. And Antonio says, yes, I will also do likewise, provided there are two things that he had to do. One, become a Christian. He had to give up the Jewish moneylender act. And second, his daughter was betrothed to Lorenzo, who was also Christian. All the money, therefore, that ultimately came to him would have to then be given to, after he used it, to his daughter and his prospective son-in-law. And finally, with the words, I am content, poor Shylock retires. Now, the backdrop, therefore, of Merchant of Venice is what framed our law. And it is after this kind of situation that roles really got reversed after the Industrial Revolution. Because what happened was, you no longer had individual moneylenders. You started having corporate moneylenders. You started having banks, you started having financial institutions. And you started having corporate debtors. And as a matter of fact, the boot now was on the other foot, because it was the corporate debtor who would default on his loan for no valid reason, except that he could use the money elsewhere. And with this backdrop, we had the Sikh Industrial Companies Act, which was spoken on. Now, that act focused only on the corporate debtor and how to get it back to its feet. It was a laudatory measure in its time, but it failed really because of two reasons. One, because of the time consumed in the process. And second, because of a moratorium provision that was extremely harsh, Section 22, which ultimately interdicted anything or any recovery process, whether by way of a suit, proceeding, execution, etc., to recover what was owing. The net result was that the company which owed these huge amounts continued to merrily carry on business for years without paying back these amounts, and the secured creditor really fell completely on his knees and had to beg for money now to infuse into the economy. Now, after this act failed, the focus now shifted to the creditor, and the Recovery of Debts Act of 1993 then tried to speeden up the process by having, instead of the BIFR, you had now debt recovery tribunals, which was supposed to speed up the process but didn't really. Then you had the Securitization Act, which gave the creditor the right to now move on his own without entering the judicial process, which the creditor did. But then even that was ultimately lopsided, because the law took the view either of the debtor or the creditor and not all the stakeholders involved, because when you have the corporate form, you have so many stakeholders. You have shareholders, you have workers, you have so many others as well. For example, operational creditors, etc. Now, with this scenario, finally, the Insolvency Code was enacted. And as I said, it came to me absolutely brand new. And in one of the first few judgments, I remember in the innovative case, one had to go through the code, understand what its raison d'etre was. And trying to understand its raison d'etre meant plowing through many committee reports, many UN resolutions, etc. But ultimately, one was able to realize that this code now had something very different in mind. It had not only the creditor, it also had the corporate debtor in mind, but in a very different way, to try and bring it back to its feet by changing the erstwhile management, which happened immediately. So, the first important change was that management went away from those who brought the company to a grinding halt. This management had to be carried on, obviously, by professionals until the committee of creditors, properly so set up, was able to choose a resolution applicant. The resolution applicant being an entrepreneur who was willing to submit a resolution plan to put the company back on its feet, as a result of which you had creditors, you had workers, you had shareholders, and you had the debtor all benefiting. Now, it was found that any one financial creditor could trigger the code. That was important. And that pointed to the fact that it was a proceeding which was very different in nature. And so long as that financial creditor was owed 1 lakh or more, and there was a default, the default may be disputed, it is enough to trigger the code and set this process rolling. I remember the next judgment that came to me was the judgment in Mobilox, which judgment then dealt with the operational creditor, properly so to speak, because the code divides the two types of creditors not into secured and unsecured, which is known to law, but into those who are financial, that is those who give loans, and those who are operational, that is those who sell goods or services. And so far as operational debtors are concerned, there's a completely different scheme. There may be a default, but the moment there is a notice which either remains unanswered or which is not answered satisfactorily in 10 days, showing that there is a pre-existing dispute, again the code gets triggered. When it came to Macquarie Bank's case, I realized that this was a special piece of legislation which had now to be construed purposefully. You will remember that you had that famous ditty which said, "I am the parliamentary draftsman, I compose the country's laws, and of half the litigation, I am undoubtedly the cause." Now, this probably happened also because words were not construed in their context. You had a very old judgment, Hayden's case, 1584, where Lord Coke said, you must first see what was the law, he put it in, as in England, the common law, before the parliamentary statute. Then he said, after that, go into why was this law necessary? What was the mischief that was sought to be suppressed? Then see what was the law enacted and see what was the reason for it. Now, all this is very good, but then what happens to the literal language? The literal language of the statute must also be given weight. So in Crawford versus Spooner in 1846, much later, you had what was called the golden rule of interpretation, by which now the pendulum swung the other side. And the golden rule was, whatever the literal meaning of the words, they alone have to be given effect to, short of some absurdity arising. And this was again picked up by the House of Lords in 1857 in Ray versus Pearson. Now, while the pendulum shifted between looking at the object alone and then looking only at the literal terms of the statute, finally, there was a doctrine which looked at both, and it was called creative interpretation, which I think is the correct doctrine which everybody looks at today. And it is that, of course, you look at the object first, then fortified by the object, you will certainly look at the text, but in its context, which is most important. So you have object, text, and context, all of which lead now to what is called a fair interpretation. And it was really this that I had in mind in order to unravel a lot of knots that came with this code. As a matter of fact, in the very next judgment, SBI versus Ramakrishnan, we utilized this concept of fair interpretation and saw the contrast between section 14 of the code, which is the limited moratorium provision, and contrasted it with 22 of the SIC Act, and said that guarantors are not persons who are covered by the moratorium, even though they were by the SIC Act. In ArcelorMittal, shortly after, there was another new provision added, because as the code was worked, loopholes had to keep being plugged. Now, one major loophole was the erstwhile management coming back into control through persons who were related to them in some way, or persons who acted in concert with them in some way. So we had a new section 29 capital A, which had to be construed. And then that was construed, and one loophole sought to be plugged. The other loophole was that time was getting extended. You heard Justice Bhushan speak about the time limits within which all this had to be done by persons approaching the High Court under Article 226. So we had to caution the High Courts, telling them that while the process was on, please stay your hands and allow the process to complete itself, after which challenges may take place. Then in another matter, I remember in BK Educational, we had to deal with another new provision, 238 capital A, which now said that the Limitation Act applied. So the question that immediately came to the forefront was, from what date did it apply? Did it apply from the date on which the cause was? Did it apply from the date on which the act came into force? Did it apply from the date on which the amendment came into force? And ultimately, by applying fair interpretation, we came to the conclusion that it would apply only from the date on which the original Insolvency Act came into force. Obviously, a dead man cannot be resurrected, because otherwise you have claims of 1993, etc., which are now sought to be enforced and which were not enforced earlier. So this sort of process went on. And then in an important judgment in Swiss Ribbons, we had to deal with the constitutional validity of yet another amendment act. And there had to basically lay down that this is a proceeding sui generis. It's really a proceeding which is in rem, as opposed to a proceeding in personam for recovery of debts. And there again, we had to grapple with various provisions. And ultimately, we were able to uphold the amendment, stating that experimentation is something which is inherent in life and in law. And that is where that famous sentence occurs, where we said that the debtor's paradise now is lost and the economy's rightful place has been regained. The opposite of the Shylockian situation. And it went on in this kind of way. Interesting cases kept coming. Another very interesting one I remember was the SR Steel case, where we had to actually say that the decision to accept a resolution plan is essentially a business decision. And it is best taken by the stakeholder who is most affected, namely the financial creditor. So the court started with a figure of 75%, saying that the committee of creditors, if 75% of them say that resolution plan A should be accepted, only then should it be accepted, and then made binding on everybody. They found that threshold too high, so in the working they reduced it to 66%. We also had to deal with the role of the resolution professional, because the resolution professional is the very important intermediary which sets the ball rolling and continues with the company as a going concern until finally the new management takes over. So one of the questions that arose was the resolution professional's role adjudicatory? And I remember that we had to say, no, it wasn't. That the idea was essentially that he had to dress the entire thing up, see that all the requirements, procedural and otherwise, were met, and then put the resolution plan to the committee of creditors, whose real decision on merits was final. We also had to deal with judicial review, because too open-ended a judicial review would mean the NCLT and NCLAT interfering with what the financial creditors thought would be good for the company. So we had to restrict judicial review to a bare minimum and say that, look, please see that only the provisions of the Act where the resolution plan are followed. Otherwise, the merits of the plan is not something that you should go into. Now, all these very interesting aspects had to be gone into in detail. I remember one other judgment, and I think that was a judgment in P. Mohan Raj, which again dealt with a very interesting question, which is that under Section 14, this is the limited moratorium provision, could it be said that a Section 138 Negotiable Instruments Act proceeding would be covered? Now, on the face of it, a 138 proceeding is a criminal proceeding. Obviously, when you are talking of suits or proceedings in the section, you are talking of suits or proceedings which culminate in money decrees. Criminal proceedings don't culminate in money decrees. So we have to go into the true nature of this proceeding and say that it was quasi-criminal. And being quasi-criminal would really be covered, because in essence, the idea of 14 was that while the resolution process was going on, no monies should be recoverable. And here, the obvious intent of the legislature was that this should be an easy method of getting back your money in a check bouncing case, because the fine there was used always as compensation and could go up to twice the amount of the check. So you saw that these and other interesting questions kept cropping up, and we had to keep dealing with them. The code kept being amended and continues to be amended, I understand, because in the practical working, of course, you have difficulties which have to be ironed out. You have seen that the book is a heavy book. I almost dropped it, if you remember. I remember years and years ago, Justice Madan, who used to enjoy himself thoroughly on the bench, was asked by some young junior for an adjournment in what he said was a heavy case. And the case happened to be an admiralty case. So the judge shot back and asked the junior, "What is the weight of the vessel?" So the junior was completely flummoxed, at which the judge said, "You said it was a heavy case, right? The vessel should be heavy, isn't it?" Now, this book deals with very, very heavy matters and deals with them lightly and well. I went through it and found that by and large it was lucid. It also tackled problems which may possibly arise and which have not yet arisen. And I therefore heartily recommend it to not only the practicing bar, but to members of the NCLT and the NCLAT, because it is important that we have uniform and quick decisions. Quick decision making is very, very important for this process, because if this process goes on and on, then you will come back to the bad old days in which you will have to find some other mechanism with which to resolve these disputes. In fact, a very witty and beautiful introduction by Justice Ram Subramaniam ends by saying that if we don't watch out, the insolvency code itself will require a resolution plan. So, hoping that that day will never come, I heartily commend the book, and thank you all very much.
Thank you, sir. I request Mr. Justice Rao now to deliver it.
Rohinton, Ashok, Ramakrishna, judges of the Supreme Court, past and present, judges of the High Court, Justice Goyal, Chairman of NGT, Attorney General, members of the bar, senior and the other junior friends, Rajkumar, Director of Jindal's Global University, and my friends and family who are here for this book launch. Good morning. I try to keep things simple normally. Before I start this small lecture, I would take this opportunity to congratulate Justice Vishwanathan on his elevation yesterday. On my behalf and on your behalf, I wish him all the best. He'll be an excellent addition to the Supreme Court, and I have no doubt he'll keep the flag flying very high. And I also invite Justice Ram Subramaniam and Rastogi and the others joining our club. One of them, both of them I think will be retiring in June. There are others who have already joined our club, Justice Hemant Gupta and others. They are on the cusp. It is, as Justice Shah was saying, it is only a second innings. And it's not as if we have retired, we'll be only doing something better. I like to keep things simple, but it did not work this time. You must have seen the e-invite. I didn't get the cards printed. And I have a friend in Singapore. His name is V.K. Raja. He is the one who wrote that emergency arbitration award, which was dealt with by Rohinton. He sent me a text saying that congratulate Rohinton on my behalf for writing such a good book. And Justice Indu Malhotra sent me a text saying, sorry brother, I will not be there. And congratulations on the book written by Justice Rohinton Nariman. My law researchers were pointing out to me initially, sir, there might be a confusion in this. But I said, it's all right. He said, our book, and my name is at the foot of the invitation. But it didn't work. How I wish Rohinton writes a book on corporate insolvency. I could not have thought about anybody else to release this book. Rohinton has been a friend for more than 30 years at the bar, as well as this side of the bar, being a judge. We just got a taste of his memory, extraordinary intelligence, clarity of thought and expression. I have been the recipient of all this for a long period of time. It's not only law that he is well versed with. He is excellent in religion, literature, history, not only his religion, comparative religions. At the bar, we were the first in reaching the court. Before 10 o'clock, we were at the coffee shop. Today also, when I went to his house to pick up 9:30, he said, now let's go. So I was reminding him that you always want to be early there. And even when we were judges, me, him, and the present Chief Justice were the early ones in the launch. About 10, we were there, and then. So he used to share his experiences, he used to share his knowledge. It was always a pleasure hearing him. As he just said, making a law is only the starting point of troubles of the consumer of law. Especially a complex law like this, clever lawyers and intelligent lawyers will start interpreting it in different ways. So interpretation of the provisions of the Act would become very important. And Rohinton, fortunately for all of us in this country, is the person in whose lap this law landed to start with. And he referred to all those judgments, which I thought I'll speak anyhow. He has finished his job of mentioning all those judgments. And he gave a direction to this law. And by interpreting certain provisions, which were capable of being interpreted both ways, he took it upon himself to interpret the law. There was a case of personal guarantees which came up before me when I was sitting with Justice Ravindra Bhatt. There was a notification issued by the government bringing into force the provisions of the Act where personal guarantees also would be liable. Then I was telling the lawyers, why don't you have the High Court decide so that we'll have a judgment. Madhavi Diwan was appearing for the Union of India, and then she told me, or told us, that Justice Nariman took up most of these insolvency matters because they had interpretation of the statute which had to be done at this level so that there will be clarity for the NCLAT, NCLT and other fora which are deciding matters, instead of leaving it to them where there is going to be more suspense and there are going to be more judgments, conflicting opinions coming out of various provisions of law. I was impressed, and then we withdrew all the cases from the high courts, and then we heard and there was a judgment. So the law itself is for the purpose of improving the ease of doing business, resolution of insolvencies, and ultimately good for the economy, which has really helped the country. But as he was pointing out to Justice Ramasubramanian's introduction, I should thank Justice Ramasubramanian for his introduction. Anybody who was opening the book, some of my friends opened the book and they were impressed by the last paragraph, the maladies in the law which still have to be taken care of unless they are taken care of now. The IBC itself would require a resolution, is what he has said, which means that though there was some direction by resolution by the Supreme Court in interpretation of certain provisions, still there is a lot to be done. I was speaking to Justice Bhushan. He also said that there are certain modifications which have to be done, some alterations to the law, certain issues which have to be resolved insofar as the working of the law is concerned. But that's a continuous process. It is good that Justice Rohinton dealt with this subject to start with, where there is some uniformity in the interpretation of several provisions. Even we were grappling with certain issues when me and Justice Bhushan Gawai were sitting together for about a year and a half, when these matters were coming up before us. We were shown judgments of the Supreme Court on limitation, where there is a difference of opinion. And even Justice Rastogi, me and Justice Hemant Gupta were sitting together when these issues were cropping up as to limitation, what should be the law, whether there is any clarity. But ultimately now, if you read the book, we have dealt with all these judgments, and then we have said, at least now there is no problem of this limitation. There are certain aspects which have been dealt with in this book, where we said that the Supreme Court has to now pronounce a judgment on certain difference of opinions. Why this book? After my retirement, I found that it was very difficult to adjust. July came, and then all my colleagues were going to court. All lawyers are in court. For about 35 years, I was in court, and suddenly I was asked to sit at home. I don't like being idle. At that point of time, Avinash came to me. Avinash joined my office when he was studying in Amity. As a law student, he came and then he said that I want to intern with you. But in a month or two, I found that the boy was very sharp. He was working very hard. And thereafter, after finishing his law, he went to Oxford on a scholarship, came back, and then started practicing in Madras. He was doing, he was assisting Mr. Arvind Pandian, former additional advocate general and senior advocate. He's here today. And he practices mainly, not that he does only exclusive company law work, mainly at the NCLT, NCLAT. He has been doing very well. He came to me and said, sir, why don't we write a book? I said, I don't know whether I'll have the time. As of now, I have the time. Then he told me, I've already started writing this book. Then I told him, if you want this book to go in my name, then I'll have to contribute to this. So I spent about 5-6 months every day, 3 to 4 hours with him virtually. He was in Chennai, and then we used to read everything, and wherever there was a doubt, making corrections. And then he used to tell me that there's a difference of opinion on this point. What would be your view? What view would be support, etc. It was a great learning for me also. Thanks, Avinash, for getting me into writing this book along with you. And I'm sure you'll do very well in the future, write more books. Right now, I don't know whether I'll be able to spare more time. As you know, most of the retired judges get into these arbitrations and they don't find time to do anything, especially with lawyers who don't want to work during daytime. They want to come and have arbitrations only in the evenings or on Saturdays and Sundays. Justice Rastogi, I'm telling you, don't permit them to do this. Ask them to do full-day work. Arbitration is full-time work. But this book has come out, and I went and saw Justice Ashok Bhushan. Both of us were sworn in on the same day, but even before we became judges, I was fortunate in appearing before him in Allahabad as well as Kerala. So that familiarity was there. And as you have seen from his remarks, he is a very good judge, a thorough gentleman judge. I never saw him raising his voice, even as a lawyer as well as a judge sitting with him. And when he accepted this appointment as chairperson of the NCLAT, I told him, do you realize that you have to work harder than you were as a Supreme Court judge? 2 years into this job, recently when I was speaking to him, 2 more years, but he's enjoying his work. That's more important. I wish him well, and thank you very much for being here and being with me insofar as this journey is concerned. And I thank all of you for being here. You have been of immense support to me for all these years. I know all of you for so many years, having worked with you as a lawyer as well as seeing you in court. This book is not only for a legal professional. As I was going through it, I was actually looking at it conceptually. It is not dealt with section-wise, but it is dealt with step-wise, and it also deals with issues. So whenever you want something, you can just go to the index and then look at it. So even a common man who has some litigation, it's not a storybook. People can't just buy it off the stands and read. But otherwise, if at all somebody has a litigation, he would be interested in knowing what his case is about and then what is the law on that. So it will be much easier for even a person who is not a legal professional to be acquainted with this book and to be comfortable in reading this book. I was trying my best to reduce the number of pages in consultation with Ravi, but it was not possible because of the width of the subject and the law as it is laid down by the NCLT, NCLAT and the Supreme Court within these 6-7 years. This is a nascent legislation, but so much has been done by the NCLT, NCLAT as well as the Supreme Court. So I wish that this book reaches everybody and then people would be enriched by reading this. And at the last, I would thank the publisher for pushing us. They wanted to release this book in December. I told him, no way, I can't do it in December with so many subjects, so many chapters being written. Thanks for his patience and ultimately bringing out this book on time. Thank you very much.
I now request Avinash to come on stage to the vote of thanks.
Honorable Mr. Justice Rohinton Nariman, former Judge Supreme Court of India, Honorable Mr. Justice Ashok Bhushan, Chairperson NCLAT, Honorable Mr. Justice L. Nageswara Rao, Honorable Present and former Judges of the Supreme Court of India, Justice Ramakrishna Prasad, Honorable members of the Delhi High Court, National Company Law Appellate Tribunal, National Company Law Tribunal, senior advocates, my learned senior Mr. Arvind Pandyan, advocates, other professionals, clients, ladies and gentlemen. It gives me immense pleasure to be delivering the vote of thanks at this book launch event. A vote of thanks in a book launch event entails thanking at least 3 sets of people. 1, those who've been inspirational and instrumental in conceiving the idea for this book. 2, those who have helped us in writing this book. And 3, those who have honored us by being here with us today. Firstly, I would like to thank my learned senior, lead author, Honorable Mr. Justice L. Nageswara, for giving me this opportunity to co-author this book with him. The process has been truly enriching, and I'm grateful to you, sir, for all the guidance, support, and encouragement that I've received from you over the last 10 years. I'd like to thank Honorable Mr. Justice Mr. Rohinton Nariman, former judge, for delivering yet another extraordinary address today, sir. We've all enriched from it greatly. I'd also like to thank Honorable Mr. Justice Ashok Bhushan for penning a wonderfully detailed foreword for the book and for this detailed introduction delivered at this occasion today. I thank Honorable Mr. Justice V. Ramasubramanian, who has been a great source of guidance for my wife as well as me. On behalf of Justice Rao and myself, I would like to thank him for his wonderful introduction, which is rife with wit, which is so personal to him. I thank Honorable Mr. Justice Ramakrishna Prasad, Judge of the Andhra Pradesh High Court, for joining us today and delivering the welcome address. I am grateful to you, sir. I would like to thank my senior, Mr. P.H. Arvind Pandyan, Senior Advocate, who has given me various opportunities to learn this subject and experience it firsthand, and for giving me repeated inspiration and for writing this book. I would also like to thank Mr. R. Shankar Narayanan, ASG South, for his support, mentorship and guidance at various stages of writing this book. It is my pleasure to acknowledge the team that has worked closely with me in bringing this book out. I acknowledge the contribution from my colleagues, Mr. Gautam Shivshankar, Mr. Shailendran, Mr. Pavan, my wife Harshini, Mr. Jerin, Mr. Arvind Srivatsa, Mr. Ujjwal Jain, and Ms. Anita Subramaniam. I'd also like to thank the team from LexisNexis, led by Arjun Bhargava and Priyeshwarya, for their support through the process. I thank all the dignitaries, senior advocates, and well-wishers who have joined us today for this book launch. A special thanks to everyone who has come to join us from various parts of India. Your support and encouragement are very important, and we thank you for taking time out of your busy schedule to join us today. Before I conclude, I'll also like to thank our respective families and friends who have joined us today. Without their support, love and affection, none of this would be possible. Thank you. Jai Hind.
Hours and hours.